And here we go. All right. So today we're going to talk about Medicaid and VA planning for everyone. And this is the second of our winter webinar series. I'm going to attempt to share my screen here. Okay, can everyone see my screen okay, hopefully?
Yes.
All right, thank you. Okay, here we go. Medicaid and VA planning. So last week I talked about kind of an overview of some of the things that people should be considering. And one of the things that I talked about people should be considering as far as estate planning goes and just overall elder law planning issues. One of the things I talked about was that I was going to go a little more in depth with Medicaid and VA planning today. And this is in the context of long-term care. So we're going to start here. So Medicaid and VA benefits for long-term care, again, we are talking about people who need assistance with activities of daily living. So these are things that people need to do every day: bathing, toileting, eating, transitioning, getting dressed, all of the things that you do on a daily basis, and that as people get older, they need assistance with. So we're talking again about people who require that kind of assistance and figuring out how to pay people to help them with that stuff. Both Medicaid and VA have options to help pay for long-term care. Both of the programs I'm going to talk about today are means tested, meaning that they have asset and income requirements that must be met in order to get this kind of assistance. Each of them has their own pitfalls of planning. So I'm going to talk a lot about how they interact with each other and why you might want to consider both when considering one or the other. And understanding how they interact is really vital here. So I want to talk first about just the general requirements. So VA aid and attendance. This is for wartime veterans who require assistance with activities of daily living. Now, when you're applying for aid and attendance, this is a pension side benefit. So this is not a disability benefit. If you're injured while you are serving your country, you can get VA disability based on that service-connected disability, connected somehow with when you were serving your country. This we're talking about is actually a pension benefit, and this gets confusing for people because it seems like, because it's got these physical requirements, that it would be a medical thing on the disability side of VA, and instead it's not. It's on the pension side of VA. It's a benefit paid simply because this person was a wartime veteran or the spouse of a wartime veteran. So when you are showing that you do need assistance with activities of daily living, when you're applying for aid and attendance rating at the VA, then you're going to have to evidence this either by a statement from your doctor and or your facility, usually both. So if you're in a facility, you're going to want to get a statement from that facility about what kind of care they're providing for you. And you're also going to want a doctor to do an evaluation and say what's going on with you and why you need this assistance. Your income is another requirement. So that's the physical requirement. And then there's an income and asset financial requirements. Your income must be less than your recurring monthly medical costs plus the maximum monthly benefit. That's a big mouthful that basically means if you're spending almost as much or more on your care than you're bringing in income each month, then the VA is going to give you a benefit up to a certain amount. So for a single veteran, that amount is just over $2,300 a month. So if that person has medical costs that are, facility and medical costs, so this does include the cost of long-term care. So if the person is in a facility and their monthly costs at the facility plus their health insurance is $4,500 a month and their income is $3,000 a month, then they're going to meet that income requirement, and VA is going to pay them up to the point where they're making $2,300 a month. So they'll pay that $1,500 a month. Up to $2,300 a month, not up until they're earning $2,300 a month. But they'll pay that $1,500 a month plus actually a little more another $800 a month there, um, so that the person still has some income each month and can pay for things beyond just their care and their medical costs. And then there's an asset requirement. So in this case, your assets, your total assets, and this includes the assets of your spouse if you're married, must be less than $130,773. Um, that does not include home equity. So if you live in your home and it's your personal residence, then it's not included in that number. Pretty much everything else is, though. In fact, some things that Medicaid doesn't count as assets, VA does, and I'm going to talk about that when I get to some of the Medicaid requirements. All right, so want to dig a little bit more into what is a wartime veteran for the purposes of this benefit. So VA considers you a wartime veteran if you served at least one day during wartime. VA has designated dates for this. This is not just things that were called wars. This is also conflicts. And if you go to their website, they've got a list of these dates to these dates. And if you served a day during that time, then you qualify as having served during wartime. You do not have to have served on foreign soil. You could have gotten in basic training the day before the war ended, and you still can qualify for this benefit. Um, Service in the reserves is not enough unless you were actually brought up to active duty, but Coast Guard and National Guard is sometimes enough, depending on what your service was at the time. Then you must also have served 90 days at least, unless you were medically discharged before that. So if you're injured and you only served 89 days, then you can still get this benefit. But you have to have been discharged other than dishonorably. So you don't have to have an honorable discharge. You can have a different kind of discharge, but if your discharge is dishonorable, as with all other VA benefits, you cannot have access to this one. So how does VA pay this benefit? As I said, it is a pension rating, is what they call it. So what you do is you apply for VA pension, and then you also tell them that you need aid in attendance. That is the term they call it. There's also a rating called housebound, which is almost the same thing. What that means is that you cannot leave your home. Aid in attendance means that you require the aid and attendance of another person in order to perform those activities of daily living that I keep talking about. So again, this is a rating and it determines your level of pension that you get from the VA. Because it is a pension, just like other pensions, it's a monthly stipend that gets paid directly to the veteran or the spouse of the veteran. Oh, and to be clear, you can be a surviving spouse of a veteran as well. The veteran does not have to be alive in order for the spouse to get this benefit, but the spouse must have been married to the veteran when they passed away. Excuse me. The amount of the stipend, again, is based on whether the recipient is the veteran or the spouse of the veteran. Those are different levels. They pay more to veterans directly than they do to spouses of veterans, and also whether or not they have additional dependents. So every year, the VA brings up a little chart that they say, okay, if you have X number of dependents and you are the veteran, then you get X amount of dollars. If you are the spouse and you have X amount of dependents, you get X amount of dollars. The stipend is capped and cannot increase beyond the maximum monthly amount. So if your maximum monthly amount is $2,300, then that's as much as you get. You're never going to get $2,400 or $2,500. You might get less than $2,300 if your income increases or your costs of care decrease to the point where you are doing better and paying more of your bills each month, and you don't need as much to make up that kind of minimum level of income. Level of care does not affect the amount of the stipend. So if you, other than what it costs. So if you can receive this care in home, you can be in an assisted living facility, you can be in a skilled nursing facility. It doesn't matter. The maximum amount of the stipend doesn't change. The only thing that changes the amount that you get for the stipend, again, is your income and what your care costs. If you gift assets, there is a 3-year look back period. So what that means is that if you have gifted any assets within the previous 3 years before you apply, then VA is going to examine that. And if you gifted those assets and they determine that it was within that period, they are going to penalize you for having gifted. And they penalize just like Medicaid does, and I'll talk about that when I get to Medicaid, in that you get penalized for how much you gave away. So it's every about $2,300 that you give away is going to get you a month in which VA is not going to pay for your care. Um, One of the things that VA does is that there's a maximum penalty. So you cannot be penalized for longer than 36 months. That is the longest penalty period they give you, is that 3-year look back period. Um, and finally, if your gifted amount plus the current resources that you have are less than that $130,773 limit, there is no penalty. So even if you gave $50,000 to your kid last month, if all you have left over is another $60,000, so total, that gift plus the amount that you have is less than the amount that you're allowed to have total, then VA is still not going to penalize you. They don't care if you gave away resources that otherwise wouldn't have put you over that limit. So now let's contrast that and look at Medicaid. So let's start with the requirements, the basic requirements for Medicaid. This will be somewhat of a repeat from last week for people, but we're going to go over it again in case people are watching this just having seen this video and not the others. The physical requirements for Medicaid is that you must require assistance with 2 activities of daily living, or be blind or significantly cognitively impaired and require assistance with one of them. And in this case, it does not require a doctor's statement or a statement from the facility, but instead is determined by a DSHS social worker assessment. So each state has a program by which they send out a social worker to meet with the person and to see what they can and cannot do. And they plug it all into a formula, into a program, computer program, that then spits out and says, okay, this person needs this much care and Medicaid is going to pay this much for that each month. So that's how they determine whether or not you qualify physically for Medicaid. The income requirement, your income must be less than your monthly cost of care plus your medical costs. So as long as your care costs more, care plus medical costs being prescriptions and your premium, monthly medical premium, as long as that plus the monthly cost of your care exceeds your income, then you can qualify for Medicaid. And then assets. In this case, it's a much lower number. You get $2,000 in countable assets for a single person. Plus, if they're married, an additional just over 58,000 right now in Washington. That number is a little bit different in each state. In Washington, that number can be increased up to $128,000 total if the spouse that needs care is in skilled nursing. And if that is the case, then there's a bit different of a formula. There's a math formula then that we plug in to see how much the spouse who's not needing care can keep. But if they are not in skilled nursing, then that 58,000 is the cap. Now, countable assets for Medicaid is a little bit more forgiving than for VA. So countable assets, here there are some assets that are not countable. Home, up to $595,000 in equity for a single person, and married folks, there is no limit on that equity. A vehicle of any value, as long as it's used to or available to be used to transport that person who needs care to and from their appointments. Prepaid burial plan and plot. $1,500 face value life insurance. Usually that life insurance, that small is, if it's a whole policy where it has that $1,500 value, that's usually burial insurance. I try to get my clients to just do a prepaid burial plan because it's cleaner and easier. Plus, you get more say in what actually happens at your burial. But sometimes people already have life insurance. And so as long as the face value of it is not more than $1,500, then that's not problematic. Term life insurance has no face value. So if a person comes and they have $1 million term life insurance policy, that is not going to keep them from getting onto Medicaid. And then, of course, any personal property that they own. Pretty much everything else is countable, not entirely, but pretty much. So some examples of assets that are countable, of course, bank accounts, cash, investments, Retirement accounts in Washington are countable no matter which spouse they belong to. In other states, that's not necessarily true. Vacation properties or family homes and family lake houses that maybe are owned uh, as a family or that have, you know, excuse me, been inherited from parents, those can be countable assets. Now, what if you are gifting assets under the Medicaid rules? How does this change? So, with VA, we had a 3 year look back. With Medicaid, there is a 5 year look back period. Look back period works the same way. If you gifted assets within the 60 months, the 5 years prior to when you apply for Medicaid, then the state is going to look at it and penalize you. In this case, for Medicaid, the penalty is in Washington is approximately $10,000. It's a little over $10,000, and for each, so we're going to use 10,000 to make it simple for the math I'm going to do later. So you're penalized 1 month approximately for every $10,000 you gifted away. So that number is significantly higher than VA, which results in shorter, because it's the denominator of the fraction, results in shorter penalty periods than you get under VA for having gifted the same amount of money. However, you can be penalized for longer than 5 years when you are applying for Medicaid. So this is different from VA. VA limits you to a 3 year look back period, and I'm sorry, a 3 year penalty period. There is no penalty for Medicaid. So if your penalty period is going to be longer than 5 years, what you really want to do is just wait out that look back period. Because if you gifted assets that would give you a 6 year penalty period, you're going to get the full 6 years when you apply if you are applying under Medicaid. And an important thing to note for some stuff I'm going to explain a little bit later, that penalty period begins once you are otherwise eligible for Medicaid. So that penalty period does not start until you're down below $2,000 in countable assets. Otherwise, they will not start that penalty period. So if you have $10,000 in the bank and you gifted away $50,000, you're not going to get your 5 month penalty period started until you've spent $8,000 of that money first. So another thing that comes up, can you get both? Can you get both VA benefits and Medicaid benefits? And the answer is not exactly. Um, when you are on Medicaid, you participate a portion of your income towards your care. And most of your income, if you are in a facility, goes towards your cost of care. And then Medicaid pays the difference. So this is different from the way that the stipend works under VA. Medicaid pays for the difference between whatever your care costs and whatever your income is. Excuse me. And when you're on Medicaid, you get to keep some income to pay towards your medical insurance premiums and a personal needs allowance. And that personal needs allowance is usually between $60 and $90 a month, depending on what state you're in and what the rules are. They just raised it up to about $70 a month in Washington. Once you're qualified for Medicaid, your VA aid and attendance pension stops. But what you do get is to keep a higher personal needs allowance. So you get to keep that full $90 per month if you are on VA aid and attendance, but they stop paying that pension because VA is always a payer of last resort. So if Medicaid is paying for your care, it's paying for the full amount of your care, you don't have a deficit between getting what your care costs you and what your income is anymore. So your income for VA purposes is no longer negative. And so VA is not going to continue to pay each month a stipend that's just going to go towards the facility to pay for your care and makes the state pay less. VA would far rather that the state pay than that the federal government pays. So they are always a payer of last resort. And folks who have VA medical insurance will tell you this as well, that TRICARE for Life is great as a supplemental insurance, but it's always going to pay after all of the other insurances have paid first. So same goes here with long-term care benefits. So which one is better? It depends. And yes, that's the lawyer's favorite answer, and I can never help but point it out when we use it, but it does. It depends. Um, if your cost of care is more than your income, but not by much, so up to the VA stipend amount. So if your cost of care is $2,000 more than your income, and that VA stipend would make it so that you can pay each month in full, and your costs of care are likely to remain steady. So they're not going to increase and it's not going to go up above that amount. Then VA can be really useful. It's a tool we use when a person has a private pay requirement at a facility in particular, because it can help them make that facility payment without using up as many resources. So, a private pay requirement is a requirement set by a facility that will eventually take Medicaid from its residents, but it's a contracted part of the entry into the facility. And what those contracts say is you're going to pay privately for 2 years or 3 years or 1 year, whatever the requirement for that facility is. And then we will allow you to transition to Medicaid. So if the people or the person who is going into the facility does not have the income to pay their costs of care each month, but they do have enough income that that plus the VA stipend will cover it, then they can pay for that care even if they don't have a bunch of resources put aside, or they can stretch those resources longer because the VA stipend helps them pay for that care. However, if your cost of care is a lot more than your income, or your care needs are steadily increasing, then it's much more useful often to go directly to Medicaid. People who need aid and attendance pension are extremely likely to eventually need Medicaid. It is the rare situation I see that income plus aid and attendance will really keep a person able to pay their cost of care for the rest of their life. It's usually something that happens for a while, but then care needs increase for almost everyone as they get older. And eventually, that cost of care just gets to be too much higher than the incomes that people normally have as they age. And people who age have lower incomes and higher assets. So that the person who's receiving aid and attendance and can pay for their care for a while will eventually get to the point where they need Medicaid benefits. Because remember that also, in order to qualify for that aid and attendance, they had to have $130,000 or less. And so if they eventually get to the point where their cost of care deficit each month is $4,000 or $5,000, they're going to run through that money that they had set aside and eventually need Medicaid anyway. So this is why I say it's really important to plan for both and to see how they intersect. So let's look a little bit at some of the strategies and differences in planning between VA and Medicaid. Now, with these strategies, we're talking about how to qualify. So we're not necessarily yet talking about, I will talk a little bit about how to um, set aside and preserve some assets. But first, I want to talk about just qualifying for VA and qualifying for Medicaid. So when planning for VA, there are some strategies we use. Um, One of those strategies, if you have too many assets, is that you can gift away those excess assets and wait the 3 years. So you'd want to make sure that you have enough money to pay for 3 years of care if you do that. But sometimes that makes a lot of sense for people who um, have a lot of assets and can afford to preserve some of them by gifting them away and then holding on to enough to make sure they can pay for their care for those 3 years. Another option is to spend excess assets on a bigger house. Because remember, your house doesn't count towards your assets for VA purposes. So if you have a small house and maybe some extra assets, you could always spend those on a house that's not going to count against you and bring your asset level below that 130,000 and then qualify for VA benefits. Another thing you can do is just simply to spend down on your care until you've reached the limits and then apply. For Medicaid planning, we have a much larger selection of strategies. And this is because the rules about gifting and what you can have for assets are more complex. And also, with that gifting divisor being so much larger, it is possible for us to work on preserving assets and also qualifying people for care in a much shorter time frame. So, Um, want to talk first, and so these are different depending on whether you're married or single. So married couple strategies, I always start here because there are fewer of them, and they generally help us not only get someone qualified for Medicaid, but preserve assets for the spouse who doesn't need Medicaid. So in these situations, I'm talking about a married couple where only one of them needs care, not both of them. So um, one of those strategies, spend down to the limits and apply for Medicaid. In this case, you might also buy a bigger house with the excess assets or a more expensive vehicle. Things that, because remember, you have no equity limit for a house when you've got a married couple. And of course, the vehicle doesn't have limits on what it can be worth for Medicaid purposes. So these are two options that work well in order to kind of get some of those excess assets down, but they stay in a equity in the house or a vehicle, something that value is kept and can still be held then by the spouse who doesn't need care. Another option is Medicaid divorce. A big caveat on this, huge caveat. This only works if both spouses have capacity. In Washington, we don't generally use this much, but for example, in Idaho, this is one of the biggest strategies that gets used. The rules of each state vary quite a bit on Medicaid. So the general rules are the same because they're federally set, but then each state has its own way of applying and its own state rules that clarify and give procedures to the Medicaid process. Um, and so Medicaid divorce works better in some jurisdictions than it does in others. However, this is true everywhere. When you do a Medicaid divorce, the two spouses are both going to have an agreed divorce, and they're going to ask the judge to give them a court order that divides their property in conjunction with a divorce. And if both spouses don't have capacity, so that one of them can't manage their own affairs, the one who needs care presumably can't manage their own affairs, doesn't have the requisite capacity to agree to this stuff, then if that happens, the court is going to appoint a guardian ad litem to make sure that the spouse who doesn't have capacity isn't getting left behind or overrun and that their needs are getting met. However, a guardian ad litem's job is almost never to then agree to give all of the assets to the other spouse. So um, just keep in mind that this is not something you want to try if both people don't have complete capacity. But the idea behind it is that when you give all of the assets to one spouse, the other one agrees to care for them in exchange for getting all of the assets. And that way, then the person who is newly single can apply for Medicaid as a single person, and all the assets that belong to the spouse um, that they just got divorced from will not count against them for Medicaid purposes. Another one is a single premium immediate annuity. A single premium immediate annuity is Medicaid compliant if it's irrevocable, so you can't change your mind, non-assignable, you can't give it to anyone else. It pays out in equal monthly installments over 5 years, is most of the time the case. There are situations in which it might pay over less time than that. And the state, whatever state they're in, state of Washington, state of Idaho, state of whatever state that person is living in, must be named as the remainder beneficiary on the annuity. And this means that, um, well, let me explain first of all. A single premium immediate annuity means that an annuity is a financial instrument that we use to take a lump sum and turn it into an income stream. So if you have $60,000 and you put it into a 5-year annuity that pays out in equal installments, you say, here's my $60,000, give me $1,000 a month each month for 60 months. So it becomes an income stream instead of a lump sum asset. And so that's why this is something we use as a tool for planning in Medicaid when we have too many assets, because we turn those assets into income. But we have them paid to the spouse who doesn't need care, so that income doesn't have to be paid towards the Medicaid spouse's care, because remember, they have to participate their income towards their care. And that person who doesn't need care then is the annuitant, the person whose life the annuity is based on, and the person to whom it gets paid. And that person, if they survive the full length of the annuity, they get all their money back and they get to keep it. But the state must be named as the remainder beneficiary, meaning that if that spouse who doesn't need care doesn't live the full length of the annuity, then the state gets whatever is left of the annuity payments in order to help pay for the care of the spouse that still needs care. The idea behind that is you're saying, well, one of you doesn't need care and you still need those assets to live on. So the state says, okay, well, if you turn it into an income stream, so you're actually living off of those assets and you actually need them for this full length of time, you get to keep them all. But if you don't actually need them for that full length of time, whatever you didn't use, whatever didn't come back to you, we get then to pay towards care for your spouse. Single person strategies are more varied than married person strategies, and I'm going to talk generally about them, and I'm going to explain one or two of them here at the end and kind of explain how they work. But they are pretty complex, and always happy to give more information. If you have any questions about this, feel free to email me or call me anytime. So a few of those strategies. One thing is you can gift away your assets and wait out the 5-year waiting period for Medicaid. As long as you don't need those assets, or you can keep enough assets to pay for your care and everything else you need for those 5 years. If you wait 5 years, then those assets you gifted away are not going to be penalized. You're not going to be penalized for having gifted them away. You can purchase a vehicle and gift it after Medicaid approval. You can put money into a self-settled special needs trust. So this trust is where you take that money and you give it to a trustee to hold for you. And they use that money to supplement the care that Medicaid is paying for. So the things that you need that Medicaid doesn't pay for come out of this trust. If you're under age 65, you must be disabled in order to do this. If you are over age 65, you can only use a pooled trust, and you'll still get penalized. The transfer still gets penalized for Medicaid purposes, but sometimes it's worth doing that anyway. And all of these trusts have a repayment clause after death, or in the case of the pooled trust, either the money that's left in the trust must be paid back to the state towards whatever they paid for your care, or it can stay in the pooled trust and be used for other beneficiaries in that trust. Those are the two options that you have there. So when doing these special needs trusts, though they are very useful for getting someone actually qualified at the time, this is not a way that you usually preserve assets for future generations or to pass on. But they're really useful sometimes for being able to supplement benefits for people who really need them, who are disabled. We can do a half loaf gift of the home. That is where, and I'm going to explain this generally right now because I'm actually going to go through a whole example here shortly. A half loaf gift is where you have a home and you get onto Medicaid. Once you're on Medicaid, you sell that home and then you gift part of those proceeds to someone and you retain some of them to pay for your care during the time that you're penalized. Another thing you can do is gift your home to a caregiver child. It's a child who has provided at least 2 years of care and lived in your home with you. And that care has kept you from needing to go to a facility. And it must be done right before you are going to go onto Medicaid or right before you go into skilled nursing. And then the other thing is you could have a co-owner sibling. So if you have a sibling who both of you own the home together and your sibling has lived there for at least a year, then you can give your half of that home or your part of that home to that co-owner sibling. So while you're looking at these strategies, and before we get more in depth, I want to talk a little bit about how some of those strategies might overlap and things you want to watch out for when you're looking at seeking both benefits from VA and from Medicaid and what problems might arise. So if you're seeking VA benefits first, which is most of the time the case, you want to be careful that you're not utilizing a gifting strategy based on a 3-year look back. Because if you need Medicaid after 3 years, but before 5 years, then you're going to be penalized for the entire amount you gave away. They don't share the same penalties. So this is a double jeopardy situation where you could be penalized twice. So for example, if you gave away $50,000 and then you waited 3 years and you apply, actually, let's make it $100,000. And you wait 3 years and you apply for VA, no problem, no penalty. And you are below those asset levels. Maybe you're down all the way to $2,000 and you get onto VA, and VA is helping you pay for your care. But then you get hurt or you get sick, or for some reason you have a stroke, something happens and your care needs significantly increase. And oh no, now you need Medicaid. Well, you gave away that $100,000 in order to get onto VA, and you gave it away 3.5 years ago. Medicaid doesn't care that you waited 3 years. They wouldn't have even cared if you served a 3-year penalty period with VA, because you told VA you gave away those assets and they penalized you for 3 years. Medicaid does not care. When you go to apply for Medicaid, they're going to penalize you starting right then. And if you gave away $100,000, there's going to be 10 months of care that they're not going to pay for. And if you're out of money and you gave away those assets, and so you don't have any of your money left anymore, um, now you're in real trouble with Medicaid, and it's because you were doing planning for VA. So you want to be sure that any planning you're doing for VA contemplates later on possibly needing Medicaid. The annuity planning that I talked about for couples with Medicaid works for Medicaid, but not for VA. So those annuities, those single premium immediate annuities that you might use in order to qualify one spouse for Medicaid, is not going to make those assets non-countable for VA purposes. So that's another thing to watch out for. If you're planning on both, you don't want to start down the Medicaid um, annuity route and then later on go and say, okay, well, I need VA benefits now for myself or my spouse, because those assets that are in that irrevocable annuity that you cannot undo are going to count against you. Um, Once it's certain you're going to need Medicaid, usually you're not going to seek VA. Now, remember, I said before that VA is that payer of last resort. And so if you know that you're going to need Medicaid, it's really not worth it generally to seek for aid and attendance. That decision process generally takes longer. I have had it happen where I've gotten someone approved for VA in a couple of months, but that's a rare thing. Usually it takes longer, and VA is completely unresponsive during most of the process, and they're very difficult to deal with. So sometimes it's not worth it, especially if you need the money sooner. The other thing is that when VA finally does approve it, if you have waited a while and they have paid you back benefits, because they can pay you up to a year back, then you may get a lump sum from VA when you first get approved. If you've gotten onto Medicaid in the meantime and your assets are limited to $2,000 and VA sends you a check for $15,000, you're going to get kicked off your Medicaid benefits and have to go through that process all over again. So um, that can be problematic for you later. So generally, we're looking at VA benefits first in the situations in which that makes sense, but we want to keep in our minds that eventually Medicaid is going to be a thing that's going to come up. So a little more in depth on these strategies, and I apologize for anyone who isn't a big math or numbers person, but we're going to go through some math and numbers. And I'm not going to go through every strategy. But I'm just going to kind of highlight some of the more complicated ones, and maybe they'll make a little more sense with some numbers and examples. So we're going to start with a couple here. We're going to have Terry and Pat. They're married. Terry is a Vietnam era veteran with an honorable discharge. Terry's monthly income is $2,500 a month, and monthly care costs are $4,500 a month. So Terry has a $2,000 a month deficit. Terry and Pat have a home and $350,000 in the bank. If they do nothing, their savings will slowly dwindle at that $2,000 per month, unless Terry's costs of care increase, in which case it might go faster. If Terry and Pat gift away money, they need to make sure that they have enough still in their bank account to cover Terry's care for the penalty period, which is at most, remember for VA, is at most 3 years. They're a married couple, and therefore they can have approximately $130,000 to qualify. And remember, this doesn't count their home, and also that it counts both of their assets. So if they gift away $150,000 and the penalty divisor is about $2,300 per month, so remember, for every $2,300 you give away, there's a month that VA is not going to pay for benefits. Then that $150,000 that they gave away is going to get divided by that $2,300 a month. So it gives us 65.2 months of penalty period. This is where I want to point out the significant difference between the VA penalty divisor and the Medicaid penalty divisor. So this is over 5 years of penalty period at that with that VA divisor. It doesn't matter because it's limited to 36 months in this case. But if they were to give away $150,000 and then apply for Medicaid, that would only be a 15-month penalty period. So it's much shorter with that bigger divisor. But back to VA. So Terry's going to need $2,000 per month or $72,000 over 3 years to pay for care each month. So if they keep $2,000 and they give away $150,000 or $200,000 and they give away $150,000, then Terry and Pat have $128,000 after that $72,000 gets paid to care, and they're home. So they're now below that $130,000, and Terry can now receive those aid and attendance benefits. So they've successfully given away $150,000, but Terry also got care for the entirety of that time. That's an example of why we might do some VA gifting. Now let's look at the same situation with Medicaid gifting. So again, we have Terry and Pat, and we're going to look at a higher cost of care in this case for Terry. And this would work the same. The divisors and everything work the same for a married or a single couple, but we're going to take this from the same standpoint as the VA gifting, so it's a little more uniform across. So in this case, Terry and Pat are married. Again, Terry is a Vietnam era veteran. Terry's monthly income is about $2,500 a month. And this time the monthly care costs are $6,500 a month. And that's not at all out of the realm for assisted living or memory care for a person for a month. Now, Terry and Pat have their home and they have $350,000 in the bank. If they do nothing, again, their savings will slowly dwindle at $4,000 per month. And this time, we're looking at the gifting divisor for Medicaid. So it's about $10,000 per month in Washington. And this means this time, if they gave away $150,000, there's only a 15-month penalty period for Terry in this situation. That penalty period, remember, will not begin until Terry is otherwise eligible for Medicaid. So they must have less than $60,000 together. So here, this gifting scenario is actually less ideal than in VA because that penalty period is not going to start until they're down to $60,000, which if they give away $150,000, they're not. They'd have to spend their $200,000 remaining down to $60,000. So they have to spend another $140,000 out of their money in order to get down to where that penalty period is even going to start. And then there's going to be 15 months of penalty period. So let's look at some alternate scenarios for Terry and Pat when we're looking at Medicaid. So they have some other options. Option number one, of course, is a Medicaid divorce. So if Terry and Pat both have capacity, they can enter into an agreed divorce. And here, when they get divorced, and they ask the judge to order that all of the marital assets be given to Pat. And in exchange, between them, Pat promises to take care of any needs that Terry has that are not covered by Medicaid. So now all of the assets are going to belong to Pat. Whatever Terry needs, Terry's care is going to be paid for by Medicaid. But if Terry needs something they don't pay for, then, and that might be clothes, it might be motorized wheelchair, it might be hearing aids, anything that Medicaid doesn't pay for, then that's something that Pat is promising to take care of for Terry. Option number two, Medicaid compliant annuity. So this is that SPIA, that single premium immediate annuity that is Medicaid compliant. And in this case, it's important to note that the state only cares about Pat's assets on the day Terry gets qualified for Medicaid. After that, Pat can have assets above the limit. This is very important when we do this kind of planning for couples, because if they put their excess assets into an annuity that pays in equal installments each month over 5 years, then Terry can get Medicaid right away. So if they put $290,000, so they retain that $60,000 for them as a married couple. If they put $290,000 into the annuity, then Pat's going to start getting back $4,800 per month and can keep all of that money, assuming that Pat survives the length of the annuity, then everything comes back that full $290,000. But when Terry, that month in which Terry is getting qualified, then the state says, okay, together you can only have $60,000. But as then after Terry is qualified, as Pat gets more money back, of course, together their assets are going to go above that $60,000 limit. The state does not care what Pat owns after Terry's already on Medicaid. So this is why this strategy is so good for married couples. And it's, as I said below, it's far and away the best option in states that allow this sort of annuity strategy, and most do. Right? So let's look at a situation with a single person. And again, we're still talking about both aid and attendance and Medicaid. So here we're going to use an example. Solo is an unmarried Desert Storm veteran with a house worth $200,000 and $50,000 in the bank. Solo's monthly income is $2,500 a month and cost of care is $4,500 a month. In this case, Solo would already qualify for a VA aid and attendance pension benefits, but has too much money for Medicaid. If Solo's cost of care stays the same in 2 years, Medicaid will still be necessary because at $2,000 a month, you're running through $2,000 a month and you're going to get through that $50,000 that's in the bank within 2 years. If Solo's costs increase before that, then Medicaid would be necessary even sooner. Now, of course, if VA benefits are available, then that will stretch out the time before Solo needs Medicaid. And remember, we're still always thinking about, are we going to eventually need Medicaid? So even though in this case, and this is a scenario in which I might say, okay, yeah, let's get Solo onto aid and attendance because that is going to stretch out that $50,000. And that extra $2,300 a month is going to help pay for the cost of care and cover probably some other monthly bills as well. It's going to make Solo's money last a whole lot longer. So I would say in this situation, get Solo onto aid and attendance until the care needs get to the point where Medicaid is going to eventually become necessary. So other than selling that house and spending down all the money, what else can Solo do? So here are some Medicaid gifting strategies for Solo. First thing is that Solo could purchase a vehicle for $50,000. Now the bank account is down to the point where we can get onto Medicaid right away, and there's just the house and the vehicle. And once Solo has been approved for Medicaid, then there's a rule that says that that vehicle can be transferred to a child or some other trusted person because it's an exempt asset. It didn't count against Solo when qualifying for Medicaid. So after Solo is on Medicaid, then this vehicle can be gifted to somebody without a penalty period. So that's one way, especially if that person then sells the vehicle and recoups much of the value. Of course, vehicles are you're not going to get $50,000 for the $50,000 vehicle, but even if you got 40, then you've still preserved 4/5, 80% of the money that Solo had with this one transfer, and it doesn't involve a penalty period. So that's one option. Another option, of course, is to purchase exempt assets like a prepaid burial plan and a vehicle, spend the rest on care, and then get on Medicaid when the bank account is below $2,000. Then here's where we talk about this half loaf gifting idea. So now Solo's on Medicaid. Solo has $2,000 and a home. And so how do we actually look at what this half loaf gift looks like? So first and foremost, it's important to understand that when you are doing a half loaf gift, that person must already be receiving Medicaid benefits. You do not do this unless the person is already qualified and receiving benefits. And the reason for this is that you got to remember you must be otherwise eligible for Medicaid benefits to start any penalty period of gifting. This is an essential, the most essential element of this plan. This is what makes this plan work, is the person's already on Medicaid. So if Solo sells the home for $200,000 and keeps the money, that Solo's Medicaid benefits are going to end at the beginning of the following month because now Solo's above $2,000 and is going to lose all of their benefits until they've spent down that money and are back down below $2,000. So a half loaf gift we do in the same month in which the house is sold. So if Solo gives money to a child or another trusted person from that house sale, there's going to be a penalty period that begins on the first day of the following month because right now Solo is qualified, otherwise eligible, receiving Medicaid benefits. So we want that penalty period to start on the first day of the following month. So here's the detail with numbers. So if Solo has $200,000 from the sale of the home and the cost of care deficit is $2,000 per month, and that gifting divisor for Medicaid that we're going to use here is going to be $10,000, then what we're going to do is have Solo gift $166,000 to a trusted child. So we're going to pretend Solo has a child that they want to have all this money anyway, and that they know is going to pay for anything Medicaid won't pay for if necessary. So this is the child that we're going to give this money to. So in doing that, Solo gets a 16.6 month penalty period. Well, doesn't really matter on partial months as far as Medicaid is concerned. So we round that up to 17 months because if Medicaid's not going to pay for a full month of care, then that full month of care isn't going to get paid for anyway. So we just use the whole month, even though Medicaid uses those partial months, we don't when we're calculating this stuff. So we're going to say this is 17 months. Solo keeps the other $34,000 from the sale of the home. At the beginning of the following month, the penalty period starts because Solo gave away $166,000. So the next month, Medicaid stops paying and the penalty period starts. Now, Solo has too much money to qualify for Medicaid at this point, but it doesn't matter. Solo didn't get kicked off of Medicaid because of assets. Solo was kicked off because of the gift. So that 17-month penalty period starts now. And over those 17 months, Solo is going to need $34,000 in order to pay for care. 17 months times the $2,000 cost of care deficit. So over those 17 months of penalty, Solo spends down that money until once again we're below $2,000. And now Solo can get back onto Medicaid. The entire gift, that entire $166,000 has been preserved, and Solo's had care throughout the entire process. That's the way these half-loaf gift works. So a few things to keep in mind when we're talking about all of this, and then I'm going to give you guys a chance to ask questions. So things I want you to take away from this. VA benefits and Medicaid benefits both help everyone or help people to pay for long-term care, but they're set up very differently. And the strategies for each must allow for the other one, especially strategies to qualify people for VA must plan to allow for that person to get Medicaid in the future if they need it. And that gifting under VA strategies is usually problematic for Medicaid, so we want to be really careful with those. Half-loaf gifting for a single person works well under Medicaid, but not under VA, as well as that couple gifting that we looked at back there with Terry and Pat. So there are some gifting strategies that work for Medicaid that do not work for VA. Also the annuities. So the strategies work both ways, or problematic both ways. Usually a person who has more assets can qualify for VA benefits, but will eventually need Medicaid, so you want to plan for both. So always talk to someone who understands both of these things when making a plan. Don't go to someone who just does VA. Don't go to someone who just does Medicaid. Talk to somebody who utilizes both together to make strategies work and to do the best they can in getting you the care that you need, as well as possibly preserving some assets for the future if you need things to supplement both VA and Medicaid benefits. So once again, if you've got any questions whatsoever, you can always contact me. My contact information is right here. I do free consultations and always do document reviews for people for free as well. And I'm always more than happy to give plenty of information to people. I think that information is the best way for you and I to make the decision together that needs to be made. So I am now going to stop my recording, and I'm going to then give you guys a chance to ask questions if you have any.
Liz,